Okay, good morning. We can begin the second seminar of Susan Haack. Now there is no need of presentation, obviously. Yesterday there was no need of presentation, and then
how can there be today?
And then today neither for theory. The subject for today is risky business, a statistical proof of individual causation. It's your time. Thank you very much.
Thank you. Otra vez el derecho y la ciencia. Otra vez grietas, pero otro tipo de grieta. Okay, another type of crack. Okay, I couldn't resist. Risky business. Very risky business. Okay. Couldn't resist. When I began writing this paper, my thought was perhaps at least half the audience will expect me to offer a philosophical theory about causation and then apply it to the law. And I wanted to begin by explaining why that seemed to me a very bad way to proceed. So I'm beginning with a fairly long quotation from Oliver Wendell Holmes. The law embodies the story of a nation's development through many centuries. In order to know what it is, we must know what it has been and what it tends to become. We must alternately consult history and existing theories of legislation. But the most difficult labor, the most difficult work will be to understand the combination of the two into new products at every stage. This is very, very far from an essentialist conception of legal concepts. The substance of the law at any given time pretty nearly corresponds to what is then understood to be convenient. But its form and machinery and the degree to which it's able to work out desired results depends very much upon its past. I chose a picture of Holmes with the characteristic moustache, but younger, roughly at the time he wrote this. It's from the common law. So my first section is about how legal concepts evolve, because the way I'm going to approach this is to think about causation and responsibility, recognizing, first of all, that legal concepts are not usually the same as the ordinary concepts out of which they grow. They get refined and specialized. And secondly, that legal concepts are also not, nor are any actually, but legal concepts are not stable. They shift, they evolve as the world changes. And they very noticeably, at least in the US legal system, have evolved in response to new methods of mining, of manufacturing, of transportation, especially of transportation. I begin with questions which have nothing to do with causation, but just to give you a sense of the first point. There's an ordinary concept of drunk, and there are very precise legal concepts of legally intoxicated. In Florida, for example, we have one definition for how much alcohol per milliliter of blood and another for how much breath that you... Crazy! Well, there's an ordinary conception of crazy, but there are also by now more legal concepts of being in some way or another mentally impaired than I can even remember. Right? Every jurisdiction will have different concepts of unfit to stand trial, for example, or not guilty by reason of insanity, or some states will say guilty but insane, and so on. And then there's the ordinary epistemological concept of reliability, and the rather curious legal concept of evidentiary reliability, as explained in Daubert, which was the leading US case on scientific evidence, and then embodied in Federal Rule of Evidence 702. And this is a very interesting story because Daubert is supposedly an interpretation of Rule 702. It introduces something which is nowhere in the text, reliability, and then they revise the rule to fit it. My topic here, of course, is causation. And I've just given you a few of the distinctions that US law makes about causation between cause in fact, which may be a very complicated matter of a combination of causes, and what's called proximate cause. Only the proximate cause is taken to be a legal cause. General causation versus specific causation. That's to say, if you might show that this drug has a tendency to cause this disorder, that's general causation. And then to show that it caused this disorder in this plaintiff, that's specific causation. And then, for example, there's a distinction between dependent and independent intervening causes, legally important. If you look at the history of this, it's very clear that in the US, legal ideas about what cause is, how you prove causation, when somebody is responsible, when a plaintiff has been negligent, when a defendant has been negligent, and so on, they evolve in response to the way the world is changing. New forms of manufacturing, distribution, new scientific developments, mining, transportation. You can see the legal system figuring, well, you know, it's very nice to have fast trains running across the country, but a few people are going to get smashed in crossing accidents. So how do we assign the risk? Railroads were very important. I had no idea how important the railroads were to US law until I wrote this paper. But in 1850, there were just a few hundred miles of track in the US. By 1870, there were railroads across the country. And this led to a body of law largely informed, as far as I can tell, by crossing accidents. You know, people would walk in the way of a train and get killed. And the law at the time, I think, very significantly favoured the railroads over the poor pedestrians who got smashed. So while the railroads could be held responsible for breach of duty to the public, the doctrine of proximate cause, of contributory negligence, right? You know, the guy should have looked both ways before he walked onto the crossing. The doctrine of the assumption of risk. You know, if you walk across a railroad crossing, you know it's dangerous. And the fellow servant rule, which meant that one employee could not sue another for something incompetent or negligent or so on. That's just a picture of a famous 19th century train crash. Apparently they had a great many in the early days of the railroad. Over time you can see the balance shifting from the defendants to the plaintiffs. More room for the plaintiffs to argue their cases. For example, there were new statutes regulating the railroads, the mines, the manufacturers. And then there was the possibility of suing a railroad or a manufacturer or a mining company for statutory negligence, for doing something that was negligent under the relevant statute. And there were new legal doctrines, like the doctrine of the last clear chance, res ipsa loquitur. Do you use this expression? The thing speaks for itself, comes from a ruling by Lord Pollock in an English case, where some poor guy is walking down the street and a barrel falls out of a brewery 1 floor above his head and just lands on him. And Lord Pollock argued, well, you don't need fancy evidence that they did something wrong. The thing speaks for itself. They should have had a gate on this. By the early 20th century, things were moving further in favour of the plaintiff, I think. When, for example, somebody injured by a defective car could sue even though he bought it not from the manufacturer but from a dealer. This was actually a big deal, making that chain. Okay. And then there were several cases, mainly they were hunting accidents, where you have two or more people who might have caused the injury. You know, imagine you're hunting in the woods, and somebody's carelessly just firing wildly, and somebody gets injured. Well, if there are two people firing wildly, or three people, it may be impossible to tell. Certainly at that time it was impossible to tell who fired the fatal shot. And while in a criminal case the standard of proof would be so high that nobody could be convicted, civilly they could both be held responsible, or all be held responsible. By the second half of the 20th century, the thing that was posing the big risks wasn't the railroads anymore, certainly isn't hunting accidents. It's these enormous pharmaceutical and chemical companies producing drugs and producing chemicals for industrial use, so on. And there began to be a whole new class of injury where you take the drug now, you're perfectly fine for the next 30 years, and then you get this disorder, which may have been caused by the drug you took. And there was, okay, can you imagine, if you took a drug 30 years ago, can you remember which manufacturer made it? Of course not. And if there were several manufacturers making it, how do you tell which of them injured you? Okay. The cases that are most interesting in this regard involve a substance called DES, diethylstilbestrate, okay, which was used, it was given to pregnant women to prevent miscarriage. Successfully, it prevents miscarriage. There's just one problem. If the women who take this drug give birth to daughters, about 20 years later, the daughters will, many of them, develop cancer of the reproductive organs. I actually recently met someone whose sister was a DES baby and who had been involved in this litigation because she indeed developed precancerous lesions and needed all sorts of medical treatment. Well, then there are these extraordinary cases. First of all, these are not so strange, where all the companies that were in the market 20 years ago are held liable in part depending on their market share. So you pay more the more of the market you had. And then there's this very, very strange case, Heimovitz versus Eli Lilly. Eli Lilly actually could prove it had not sold the DES that this plaintiff took. No, it never sold it in that particular part of the market, but it had to pay anyway. We're all still puzzling over the reasoning in that case. All right, now, my specific topic is the idea that a relative risk greater than 2 is a good test for specific causation. Okay. Relative risk greater than 2 means epidemiological studies show that the people who took this drug or were exposed to this chemical are more than twice as likely to get it as those who were not exposed or didn't take the drug. That's what relative risk greater than 2 means. And I think this idea is a response to a problem about the role of statistical evidence. Because not all the people exposed to a dangerous drug or a dangerous chemical will develop the characteristic disorder. And not all the people who develop that disorder will have taken the drug or will have been exposed to that chemical. So the question is, how is relevance of doubled risk relevant? Okay. In such cases, we call them toxic torts. And we joke that this is true in both senses, right? Because it's both tort litigation about toxic substances or allegedly toxic substances, and the source of much unhappiness about the workings of the legal system. These cases will usually involve toxicological studies, analyze the stuff, and you know that this component has this bad effect. In vivo studies, that means giving comparable doses to animals. In vitro studies, which means subjecting cells to this substance in a test tube, in glass is what it means. And epidemiological studies, that's to say large-scale statistical studies. I don't know if you know this. I didn't know this until I got curious. The word epidemiology derives from the Greek. Epi, which means on, and demos, the root of democracy, for example, which means the people. So epidemiology is the study of epidemics, which are diseases which are visited upon the people. Okay. Some courts have held that epidemiological evidence that exposure to S more than doubles the risk of D, S for substance, D for disorder, is a good test for specific causation. I'm going to argue that this is a bad misconception. This is a muddle, I would say. It all started with a swine flu epidemic in 1976. I think this cartoon is actually from a later swine flu epidemic, but it was the only good cartoon I could find. There they are, they've all got their mouths and noses covered with swine flu. We need to get the message across to the public that there's no need to panic. Okay. Okay. In 1976, it was believed that there was about to be a massive swine flu epidemic. It turned out to be not so massive. There was a huge program of vaccination. Everybody was encouraged to go get vaccinated. And within a couple of months of a lot of people being vaccinated, strange reports began to appear at the CDC, that's the Centers for Disease Control, which is the body that oversees the incidence of diseases. A lot of people, a very significant number of people who had had this particular vaccine against swine flu developed something called Guillain-Barré syndrome. You don't want it, right? You definitely don't want it. It starts with tingling in your fingers and your toes, and you can be completely paralyzed within 3 weeks. It's a very nasty disorder, and it's apparently sometimes caused by a shock to the system, such as surgery. And this vaccine seems to have caused the same kind of shock to the system. This had immediate legal consequences. The first was a new regulation. Somebody damaged by a vaccine should sue the government and not the manufacturers of the vaccine, the doctor who gave them the vaccine, the clinic where they got the vaccination, the government. Later, after another vaccine scare, the US set up special vaccine laws and special vaccine courts. Okay. They have been much in the news lately because of the scare about MMR vaccine and autism. The rationale behind the special laws, of course, is there is a huge public health benefit to having people, especially children, vaccinated against various diseases. But there is always and inevitably a small risk to some of the people vaccinated. And the idea was we need special laws because this is a special combination of desirability and risk. Okay. It was in this context that courts started to introduce this new test. The first was in Cook in 1982, which was a swine flu vaccination case. Mr. Cook got Guillain-Barré syndrome. He would have been automatically compensated had he got it within 10 weeks of being vaccinated. But he got it at week 13. Okay. So he had to go to court. And in Cook, the court argued that evidence of a relative risk greater than 2 was both necessary and sufficient to prove specific causation. That's a very strong claim. In Manco, another swine flu case, the court ruled that a relative risk greater than 2 was sufficient, but didn't say anything about it being necessary. They don't, of course, use these words. These are philosophers' words, but you can tell from what I quote from Manco that this is the concept. Then something very significant happens. In 1990, this idea turns up for the first time in a Bendectin case. Bendectin is, I don't know what to say. It was a drug sold for the prevention of morning sickness. Morning sickness in pregnancy, which is, for most women, just an inconvenience. For a few, requires hospitalization, and in rare cases is actually fatal. Charlotte Bronte died of morning sickness. Who knew? It's amazing what you find out when you start digging. These cases are important not just because there was thousands of cases across the country where women took this drug, gave birth to children who were deformed. They had limb reduction defects, little like thalidomide, though not quite so bad. And Daubert was itself a Bendectin case. So as soon as this idea enters the line of cases about this drug, its potential legal significance grows. That's the idea. And in DeLuca, which was the first Bendectin case where it appears, the court suggests a whole new idea. Up until then, the question was it necessary, was it sufficient, was it both? Now, the court says, this is a requirement for the evidence to be even admissible. So, unless you can show a relative risk greater than 2, you may not even present your case to the jury. I will give summary judgment to the defendants. Okay. The same year, 1990, the first edition of the Federal Reference Manual on Scientific Evidence appeared. This is a very influential book, put together by the National Institute for Justice to guide judges who have to deal with complicated scientific evidence that they don't understand. Its main importance is it gives them stuff they can quote in their ruling. Right? And it tries to explain statistics, epidemiology, DNA evidence. It's a very influential book. And in the chapter on causation in this book, you read, after a lot of perfectly sensible stuff about epidemiological studies and how they should be designed and so on, suddenly towards the end, there's a section on specific causation. And the authors say, statistical probability, that's to say that the risk involved, can be, quotes, adapted to the more probable than not standard of civil proof. So they want to equate the statistical probability with the degree of proof. And from that they argue, obviously, evidence of relative risk greater than 2 is sufficient. And then there was Daubert, 1993, another Bendectin case, which the US Supreme Court took in order to clarify the situation about the standards of admissibility of scientific testimony. In the Supreme Court case, there is no mention of this concept of doubled risk. But the Supreme Court decided the legal question, what's the standard of admissibility? But remanded the case back to the Ninth Circuit. So it goes back to California. Judge Kaczynski gets it in his Federal Appeals Court. And on remand, in a little noticed bit of his ruling, Judge Kaczynski argues, citing DeLuca, right? That's why I said it was very important this was a Benedictine case. That to be admissible, a study must show that children whose mothers took Benedictine are more than twice as likely to develop limb reduction defects. And that makes this a legal requirement on admissibility. As I think you can see, this makes it really quite easy for judges to decide whether or not such evidence is admissible, and quite easy to get rid of a large number of cases on summary judgment. You haven't produced good enough evidence even to admit, so go away. And relative risk greater than 2 as a requirement on admissibility grew more and more popular across the federal courts. In other Benedictine cases, obviously. In an enormous number, there were thousands and thousands of cases involving silicone breast implants, which were alleged to cause various connective tissue disorders. You find it in asbestos cases. You find it in Agent Orange cases left over from the Vietnam War, and so on. And you find it in major environmental cases, like in Ray Hanford Nuclear Reservation, where the people in the neighborhood were suing on the grounds they'd been damaged by radiation from this plant. And you even begin to read in cases things like this. California law requires, or Washington law requires, referring to the tort laws of various states, they require a showing of relative risk greater than 2 for admissibility. No state's law about admissibility mentions this. They all say the standard of proof is more probable than not. But once you've confused that with a relative risk greater than 2, it's tempting to say, well, that's what the law requires. So they're all relying on Judge Kaczynski's and ultimately on Manco's and Cook's dubious interpretation of that standard. And then in the second edition of the Federal Reference Manual, you get this endorsed even more firmly than before, only now, instead of giving you scientific argument, I should say, this article on causation evidence is written by about 4 people, 2 of whom are epidemiologists, and 2 of whom are law professors or attorneys. And this is actually a recipe for confusion. So that what previously was presented as if it might conceivably be a scientific idea is now presented as a legal idea, and that this is required for admissibility is now justified by citing all the cases which have already cited DeLuca or cited Dalbert citing DeLuca. I think it's fascinating to watch how this idea spreads across the country. Some state courts agreed. So there's a well-known Texas Supreme Court case, and then a well-known Vermont Supreme Court case, both identifying relative risk greater than 2 with proof more probably than not. However, if you go looking more carefully, you discover courts have never been unanimous about this. Whether a court thinks this is a really fine idea is it's a lottery, who you get. So there's a very early case, Allen, which rejects the idea as necessary. And a case the same year which reject this idea as sufficient. A very influential case which I think is more often cited wrongly than cited correctly. This is the big Agent Orange consolidated case. Agent Orange was this exfoliant that the US Army used in Vietnam, which caused all kinds of damage to the soldiers who were using it. And there was a huge consolidated case decided in 1987 in which Judge Weinstein, who is a very influential federal judge, argued that relative risk greater than 2 is not sufficient for proof of specific causation, and that it's necessary only if you have no other evidence than epidemiological evidence. But he's often miscited. A lot of people cite him as if he'd said, it was necessary. Okay, so it's cited as a positive case in this line, but in fact I take it to be a negative one. And in New Jersey, a court argued that relative risk greater than 2 is both too strong and too weak as a test of admissibility. Now they're speaking our philosophical language. I think actually he was correct, both too strong and too weak. In Majorana, the court argues the best thing to do, if you've got lots of studies showing a relative risk greater than 1, well, tell the jury about it and let them decide what it means. And in Pick, the court notes, this is important, any increased risk is some evidence that this substance might be a causal factor. Right? If there's any increased risk, if you're subjected to this stuff, then there's a possibility that this stuff caused the injury. And so to require a relative risk of more than 2 for admissibility is unfair to the plaintiffs. 3M versus Atterbury, the Texas court noticed that even though the Texas Supreme Court in Havner had been in favor of the idea of relative risk greater than 2 as a test for specific causation, it had also said this is not a bright line rule, and it used that to argue that relative risk greater than 2 wasn't necessary. And then there's a very interesting dissent in the big Vermont case, where Justice Reber manages to say, good for him, is it Reber or is it Reiber? I have no idea. Anyway, the then Chief Justice of Vermont argues, hold on, if you have to prove that there's a more than doubled risk for the evidence even to be admitted into court, this means the plaintiff has to prove his case twice. Now, first he has to prove it to get a case started, and then he has to prove it to win the case that he got started. That can't be right. Okay, I agree with him, that can't be right. Scientists were also protesting, especially those who've served as expert witnesses, who were getting very annoyed. In one case, Hall, the judge actually overruled the opinion of his own expert witness. He appointed his own expert witness, and then he said, well, I disagree with you. And that expert witness, Dr. Greenberg, wrote in protest, from a scientific point of view, it's not appropriate to disregard relative risks of less than 2. Anything greater than 1 has some scientific significance. And Sander Greenland, who is probably the best known methodologist of epidemiology in the US, and a very interesting guy, because he thinks about the epistemology of epidemiology all day, says, I can't think of any real case in which enough is known to justify the claim that relative risk approximates the probability of causation. In other words, I know of no real case where you can equate the statistical thing with this legal degree of proof thing. Some legal scholars also protested. For example, Ehrlichman is saying essentially that if you adopt this as a requirement on admissibility, you're depriving the jury of the possibility of getting a whole bunch of different bits of evidence and trying to figure out what it means jointly. Okay. And Andrew Dewars, he's a friend of mine, he teaches at a university in North Florida, writes that this idea is a textbook example of bright line legal rules trumping sound scientific principles. It's enough to drive an epistemologist crazy Right? You know, you read all this stuff and you, oh my God, is it necessary? Is it sufficient? Is it what? Two senses of what's going on? I looked all over the internet for a puzzled woman. There is no good cartoon of a puzzled woman. So, sorry, my crazy epistemologist has to be a guy. Very disappointing. Okay, so I'm going to argue that, first of all, epistemologically, right, there are two sorts of argument, epistemological and legal. The epistemological argument I'm giving you is why it's neither necessary nor sufficient. Okay, and I'll start with it's not sufficient, because it's kind of easier that way, I think, for me and for you. I think that the key argument, which you find in Cook, which you find in the Federal Reference Manual, which you find in all those cases which say more than doubled probability equals more probable than not. We can equate this with the standard of proof. I believe this is a fallacy of equivocation, and that there are two quite different meanings of probable, an issue here, which have been run together. Statistical probability, degree of proof. I would say, just by way of, I mean, I guess this is not exactly a philosophical argument, but it's rhetorically effective to point out that the legal system recognizes in other contexts that these are different concepts. Right? In this context, there is total confusion. But in other contexts, it's well known that this is a confusion. When I mention the prosecutor's fallacy, what I mean is this. It was quite common in the early days of DNA evidence for prosecutors to argue the statistical probability of a random match between this DNA from the crime scene and this defendant is 1 in, say, 5 million. Therefore, the legal degree of proof that this is the person who did it is 1 in 5 million. This is now generally recognized to be a fallacy. No prosecutor would dare try that argument again. And it's recognized to be a fallacy of equivocation. And yet, still in the tort context, this equivocation continues. Always, when something like this comes up, you can find some smart law professor who, long before it arose, had seen the essential point. In this case, it's somebody I don't know at all, Professor Jaff. I don't even know if he's still alive, but he wrote, "The conditions for a finding are not satisfied merely by having a greater statistical probability. There must be a rational, that's to say, an evidentiary basis, on which the jury can choose the competing epistemic probabilities." Dead right in 1951. So all we have to do is get ourselves back to 1951. The Supreme Court of Jersey got it dead right in 1992 when it said, evidence of a relative risk greater than 2 is just one piece of evidence among others. It's not a piece of evidence with especial significance. My argument, of course, okay, to make this argument properly requires me to rely on some epistemological theory. Okay. I shall rely on mine. Not because it's mine, but because I accept it because I think it's true. So far as I know, this is the best epistemological theory around. If I didn't believe that, I would have given it up. Okay. And according to this theory, the degree of warrant of a proposition by certain evidence, which I take to be what degree of proof is, that's the theme for tomorrow, not tomorrow, for Thursday, depends on 3 factors. How supportive the evidence is of the conclusion, how secure the evidence is independently of its connection with the conclusion, and how comprehensive it is, that's to say, how much of the relevant evidence it includes. You'll get this in much more detail on Thursday. Okay. So I'm with Keynes, with Russell, with Cohen, with Richard von Mises. There don't seem to be many people who are alive who believe this. This is kind of scary. For a while I thought I was the only person in the world who thought that epistemic probabilities, that's to say degrees of warrant, don't fit the profile of the mathematical calculus of probabilities. And for a while I was thinking, I must be dumb, I must have a blind spot. How can I know? Everybody else seems to think it's obvious that they must. I don't get it. What's wrong with me? And then I discovered, Russell, Cohen, Keynes, Richard von Mises, all saying, of course it doesn't fit. Okay, yeah, thank goodness. I have supporters even if they're dead. Okay. I think this for three reasons. Okay, and these are three reasons connected with my theory. There are three determinants of the quality of evidence and hence of degree of warrant in my theory. And because you might do better on one and worse on the other, and another claim might do better on another and worse on the one, there is no guarantee you even have a linear ordering of degrees of proof. That's the first one. The second problem is that the probability, the mathematical probability of P and the mathematical probability of not P must add up to 1. But when there is insufficient evidence either way, by my theory, neither P nor not P is warranted to any degree. Right? This is why when my husband asked me, what do you think the probability is that this will happen? And I say, I have no idea. And he will say, do you mean you think it's 50-50? And I will say, no, I don't mean that. I mean, I have no idea. I have no evidence either way. And then, third issue, the degree of warrant of, the degree of mathematical probability of P and Q, for independent P and Q, is the product of the probability of P and the probability of Q, which is always less than the probability of either, unless they're both 1. Okay. But on my theory, the degree of warrant of a conjunction of independent conjuncts may be, in certain circumstances, higher than that of either conjunct. This is an argument I've made at considerable length in another paper. If you press me, I'll give it to you here, but I'm not going to try it at this moment. Now, what that argument showed, if I've persuaded you, is that the argument for the sufficiency of this relative risk greater than 2 test is a fallacy. But that the argument is invalid is not enough to show that the conclusion is false. Right? Maybe they've got a bad argument, but the conclusion is true. Anyway, so here is my argument that the conclusion is false. First of all, yes, relative risk greater than 2, like any increase in relative risk, including relative risk of 1.1, is to some degree supportive of specific causation. On quite modest degree if the excess risk is modest. Because, in my theory, there's a connection between the concept of supportiveness and the explanatory integration of this evidence with this conclusion. And if there's an increased relative risk, then you have a possible explanation of how this guy got this disorder. But now compare the following two bunches of possible evidence that you might have in such a case. X was exposed to this substance and then he got this disorder. We know there's an increased risk of this disorder among those exposed to this substance. We also know a significant proportion of cases of S are hereditary, and that there is a history of this disorder in X's family. Then the statistical evidence is in danger of being washed out by what we know about this plaintiff. Okay. Now imagine this situation. He was exposed to S and then he got this disorder. There's a more than double incidence of D among those exposed to this. And we know that S causes the following physiological damage, X, Y, Z, W, which leads to D. And guess what? X showed signs of X, Y, Z, W before he developed D. Well, now we've got additional evidence on top of the statistical evidence pointing in the same direction that S caused it. But this is an argument why the statistical evidence is one piece of evidence among many, as the Supreme Court of New Jersey rightly put it. Okay. In any case, remember, supportiveness is only one dimension of warrant. Okay? And suppose you've got a study which shows a significantly increased risk, right? But it's a really badly conducted study. Well then, you have a very low epistemic probability of a high statistical probability, and a significantly lower degree of warrant than you might think, because the independent security is so poor. This is what the court says in Johnston. When you probe how Dr. Morgan got to his conclusion, you realize that it's a statistical speculation based on speculative dose estimates and speculative risk assumptions. In other words, it's speculation based on speculation based on speculation. So, okay, he gives us a high statistical probability, but the independent security is minimal, not to say there isn't any. Okay, so degree of proof, very low. And suppose significant relevant evidence is missing. Suppose, for example, subjects in a certain subclass are less vulnerable to this disorder than others. And less vulnerable to the effect of this substance than others. And our plaintiff falls in this class. Suppose it's smoking and lung cancer, for example. Though the relative risk is very high, it's higher for women than it is for men. Right? So if you have a male plaintiff, this degree of relative risk is less significant than if you have a female plaintiff. Right? And if you know that the plaintiff falls in a class which is less likely to be susceptible to S, then the conclusion will be less well warranted for the same degree of statistical association. Okay, it's not sufficient. It's not necessary. All right, it's not necessary. Why not? Suppose we've got evidence that the relative risk is 1.99. So it's not 2 and it's not greater than 2, but it's as close as it can get. And we have evidence that people in a certain class are more vulnerable than most to this disorder. And that the plaintiff is in that class. Then I think we have reasonably strong evidence that in this case, for this plaintiff, it was the exposure that caused the disorder. You see the idea? Of course, those arguments were very simplified. They were simplified actually in two ways. There are more wheels in my epistemological theory than I told you about. And there are more complexities in the science than I told you about, and in the legal arguments that people make. Because very often, especially more recently, an attorney bringing a case of this kind will argue not exposure to S caused my client's D, but exposure to S contributed to my client developing D, or accelerated the rate at which he developed D. So he got lung cancer at 37 and not at 67, for example. Now, I think it's obvious, I hope it's obvious, that if I took those complicating factors into account, the arguments I just gave you, not sufficient, not necessary, would be more complex, but the conclusion would clearly be the same. Right? In fact, the conclusion, I think, would be more so. Okay. That was epistemology. Okay. Now, yes, but what about the legal aspects of this? Okay. There's a complexity about Judge Kaczynski's ruling in Daubert, which I didn't mention before. Okay, but it would be dishonest not to mention it now. in a footnote which I suspect nobody ever read except me, Judge Kaczynski says, well, relative risk greater than 2 is necessary for admissibility. Of course, had the Dalberts produced evidence that Mrs. Dalbert was especially susceptible to the effects of bendectin, more likely than the average to give birth to a deformed child as a result of taking this substance, that would have been different, right? Which has been in part what I have been arguing. I don't think this gets him off the hook. Right? I mean, what he says is in the footnote is true, right? But first of all, it should have been in the text. Right? Excuse me, it should have been in the text. This is way too important to bury in a footnote that nobody will read. But more to the point, part of what he had to decide was, remember, Dalbert had changed the standards for the admissibility of scientific evidence. So the Dalberts' attorneys had briefed the case under the old law. And then the Supreme Court had changed the law. And normally the result would be, okay, go away, rebrief your case under the new law, and then come back and we will reconsider under the new standards. Right? Had they been asked to do that, then they might have come up with a better case. Who knows? Right? They might not, but they might have. But rather than allowing the Dalberts to rebrief the case, Judge Kaczynski simply said, you know, it's perfectly clear that even if you did, we would get the same result, because this would not be admissible because it doesn't have sufficiently high degree of relative risk. Well, sorry, but that argument is I don't know how to put this, it's legally all screwed up. Right? They didn't do it, but then they had no opportunity to do it. Right? And the question was, should they be given the opportunity to do it? Okay. Judge Kaczynski is a very clever guy with a very high opinion of himself, and I think often quite careless because he has such high self-esteem. Okay. All right, set Dalbert 1995 aside, forget it for the moment. The issue is about what the standard should be for admissibility, which is something for the courts to decide, and what the standards are for weight, which is something for the jury normally to decide. I agree the big Supreme Court ruling fudged the line a bit, but it's very clear even in that ruling that while judges are required to screen expert testimony under Rule 702, even as interpreted in Dalbert 1993, there was never an intention that the judge should decide the case and not the jury. The idea was not that the judge should decide on the facts and just take the jury's place. The idea was that he should determine not whether the evidence was good enough to establish the plaintiff's case, but whether it was good enough to be worth putting before the jury, which is a different concept. And the jury, of course, would consider it in combination with whatever other evidence the plaintiff could produce. Of course, you might argue, all right, well, relative risk greater than 2, epistemologically speaking, is not a terribly good test. It's a bit rough and ready, you know. But, you know, you're a philosopher. You have these terribly high epistemological standards. You know? This is the law, and we have to get cases decided somehow, preferably in a reasonable period of time. And isn't this idea of relative risk greater than 2 being required for admissibility a very convenient rule of thumb? You know this expression? An approximate rule. It derives, I believe, from an old criminal law about how it was okay for a man to beat his wife, provided the stick that he used was not bigger than his thumb. A rule of thumb, meaning a rule which is good enough for practical purposes, even though not defensible at some deeper level. But I think that's wrong. I think it's actually a bad rule of thumb, and that the conception of the relevance of such evidence that I've developed would be legally better. Okay, now what do I mean by legally better? Well, I mean it would serve the goals of tort law better. Okay, what are they? Well, I take it they are in part to, look, okay, the usual picture is you avoid risk through regulation. It's the job of the FDA to stop the dangerous stuff getting on the market in the first place. That's the Food and Drug Administration, the regulatory body that determines what you can market in the US. Food, drugs, cosmetics. Okay. Well, yeah, and then the tort system picks up where the regulatory system fails. That's a perfectly correct way of looking at it. I'm not challenging that at all. But of course, tort law can also provide a strong incentive both to be careful about your products and to withdraw them if it turns out that they're dangerous in ways you didn't know before you marketed them. Okay. What you want is for the tort system to have those effects, preferably without discouraging people from producing good, useful stuff that's also harmless. Not so easy. So the two goals of the tort system, as I see it, are compensate those people, but only those people, who are actually injured by a product, rather than having a kind of lottery, where you take the product, you get the disorder, you buy a ticket in the legal lottery, and you will get $100 million and I'll get nothing. Right? That's not a good tort system, not a tort system working well. And you also want to create disincentives to production of harmful products while creating no disincentives to the production of non-harmful products. Sounds simple enough, except for one small complication. There is no simple distinction between harmful stuff and harmless stuff. The problem with drugs, for example, is a lot of drugs are effective for many people, but not safe for all of them. Vioxx is an interesting example. Are you familiar with this name? I'm sure it was sold in this country, but I don't know under what name. It was a drug for arthritis. Most pain-killing drugs for that sort of disorder have very bad effects on your stomach. They're likely to cause ulcers, for example. Vioxx was a drug which was effective at treating the pain of arthritis and was much gentler on the stomach than the usual drugs for arthritis. But it also caused a significant increase in the rate of heart attack and stroke. As a result of which, there was a lot of litigation, as a result of which the drug was withdrawn from the market, at least in the US. And thinking back over this, my feeling is, there are probably some arthritis patients with a history of ulcers or a history of bleeding problems for whom this would be a very good drug. And another class of patients with arthritis and a history of heart disorders or cardiovascular problems for whom this drug would be a disaster. And it would actually be better if it was still on the market, labeled, do not prescribe this drug to anybody with a history of heart trouble. Right? Very suitable for people with a history of ulcers or bleeding disorders. But just take it off the market. Okay, what we want is to make the drug available to the people it would help and not hurt, and keep it out of the people whom it would hurt and not help. It seems simple enough. But what I'm suggesting is that this very simple relative risk greater than 2 test precisely makes you look the other way from that issue. It makes you look just at the general population, not at the individual person. Whereas if courts recognized this is one piece of evidence among many, neither necessary nor sufficient, then they would have to look at the evidence that was specific to the person. And this would give, first of all, both plaintiffs and defendants incentives to look at specific vulnerabilities of specific subclasses of the population. And it would enable deserving plaintiffs to recover even when the increased risk of the population is very small. This actually happened Yay! Actually happened in at least one case I know about. This was a vaccine case where a plaintiff successfully argued that his daughter had been injured by measles vaccination because she had an underlying mitochondrial disorder, which this vaccination exaggerated. Right? And this explained why she developed autism. Right? And that's the kind of argument I would like to see, first of all, brought more often, and secondly, succeed more often. At one remove, one hopes, a proper epistemological understanding of what's going on would enhance manufacturers' awareness. You know, drugs aren't just good or bad. They're good for some people, bad for others. Encourage them to label them appropriately. And I might say, in text you can actually read rather than so small that you need a magnifying glass. And encourage the FDA to encourage manufacturers to do this. In other words, hey, for once, better epistemology would also be better policy. Thank you.